Good afternoon, everybody. Welcome to our second ever LinkedIn Live Roundtable. I'm Karlee Stoppenhagen, a managing partner in Modern Family Law, and we also have with us Brian Litzinger, managing attorney out of Washington, Craig Valentine, managing partner out of Colorado Springs, and Najmu Mohseen, managing attorney out of Dallas. We are going to be talking today about litigation versus collaboration and how that impacts the divorce process. So before we kick things off, I want to just set some ground rules and some definitions because I think this is a great place for everybody to start. There's a lot of misconceptions swirling around this topic. There's a lot of well-intended things that go on with this topic. And the best place to start is, what are we even talking about? So first, I think just real quick definitions: litigation. Litigation is what most people think of as the nasty divorce process where you are in court and you have experts and trials and all kinds of lawyers and conflict is surrounding it. And there's also within that collaboration where people are working together, attorneys are working together, experts are working together, parents, spouses are collaborating and talking through what do they want their life to look like when the divorce is over. And the collaboration process leads us last to the settlement. When parties reach agreements, parents, spouses reach agreements on what they want in their case, that is called a settlement agreement, and that can be entered by the court. So knowing our litigation, mean, ugly, nasty, conflict, collaboration, work together, and settlement, we have resolutions. With those high-level definitions, I want to turn over to our panelists because from here in each state, we have a highly different process. So I think to start, let's go with our newest office, Washington. Brian, I'm going to pick on you first. Can you tell us a little bit about what litigation versus collaboration or settlement looks like in your state?
Sure. I mean, so litigation is kind of exactly as you described it. It's that traditional process that everyone thinks of, but I think the preconceived notions of what attorneys do when it comes to divorce taints that word just a little bit. Most attorneys I work with exceptions here and there, really do desire to try and keep things out of court, resolve things as much as possible between counsel and parties, reach agreements without needing to go in front of a judge. Because look, frankly, when you go in front of a judge, you're expecting a complete stranger to make determinations upon your property, your children, parenting time, all of these sort of things. We try and use that as a last resort. So collaborative law, from my perspective, is we're working together with the opposing counsel and trying to reach those resolutions. So in everything we do, there's collaboration. There is, of course, the collaborative law process in which you don't ever go to court in the first place. You sign an agreement, you file that agreement with the court, you then try and work everything, outside of court, and then you file an agreement with the court and everything's done. The problem is there's a lot of off ramps in that process. If there's any sort of disagreement that arises, that really derails everything, to the point of, if you have to file any sort of motion with the court, any motion to compel, anything you're not getting, that collaborative process ends immediately. And then you're right back to where you would have started at a just traditional divorce process. And there's really instances in which that collaborative process aren't really appropriate. If you've got domestic violence concerns, if you have a partner who you can't trust, if you're concerned about funds missing or not being disclosed, there's a lot of factors that would go into determining whether the collaborative process would be a good choice for you.
Great. Well, that sounds pretty similar to Colorado. So Craig, I'm going to pick on you next. Of what does litigation versus collaboration look like in our state?
Well, I think we don't have that formalized process that Brian was talking about that Washington has. In Southern Colorado, the jurisdictions where I practice, and I think across the state, there are rules. If you haven't done your disclosures, filed the disclosures with the court before you enter into an agreement, and then somebody tries to back out of the agreement, the court's not going to enforce that. They're going to say you didn't have the information you needed in order to enter into this agreement. And so the way I see it a lot of times is when people call us and they say, hey, can I do a collaboration, or can I do just a mediation? It's that just word that really triggers what people are talking about. I just want to do a mediation and resolve this. I think all of us, every attorney, like the dream client is two people who are being reasonable. It doesn't matter how complex the case is. It's two people who are being reasonable. And so, in Colorado, you do have to go through the court. The first step is you file the petition, you do the financial disclosures, all of these things that have to happen, but you're trying to get a resolution, and you're trying to be collaborative. So it's not a formalized process. There's not some opt out that you can do. You have to go to court. You have to file. You have to do certain steps in Colorado. But yeah, the goal, the hope, the way that we like to work is with people who want to be reasonable, who want to work together to find solutions that work for everybody.
Najmu, I know that Texas seems to be the Wild West, or maybe the Wild South compared to us Westerners, but I know that there's a lot of similarities in your state and differences as well. So can you walk us through just high level collaboration versus litigation in the state of Texas?
Yeah, absolutely. There is a lot of overlap between Texas and what I've heard about Washington and Colorado. There is a collaborative family law process in Texas, and that can mean a very specific thing. It's a process where some people choose to engage in it, and that would involve entering into a participation agreement. It would state the party's intent to resolve their marital or other issues outside of court. And it's actually something that's codified in the family code, and the family code specifies how it works, how you can seize the process, and what happens if someone chooses to seize the process. Most people don't engage in this, and most people tend to go the traditional route, and that's more common, and I think it's probably more advantageous for a lot of people, kind of for the reasons that Brian and Craig both touched on a little bit, that if something goes awry, you're starting from scratch, or you're kind of stuck in this no man's land. Whereas in the traditional route, yes, you do file your petition. Yes, we are assigned to a court. However, most cases that I handle personally don't really ever see the inside of a courtroom unless we're going to get the judge's signature on the final decree, because most of the time we can reach a settlement, and that's often best for people, whether that is in that collaborative family law approach or in through informal settlement negotiations.
Well, it sounds like there's a lot of misconceptions swirling out there, and everybody touched on it in their various answers. Like Najmu, I'm going to pick up where you left off on that of, the traditional route seems to be the best route for most people to take in the state of Texas because it is planned and there's laws for a reason and we'll follow those steps. So do you have any misconceptions, like big level misconceptions that you see when people call and they say like, Craig, I want to just do this thing? Do you have big misconceptions that you see or things that you'd like to dispel on some confusions that may be circulating around on this topic?
Sorry about that. Absolutely. So one of the things I hear a lot about this collaborative law approach is the idea that one attorney can represent both parties. I personally would never do that. I believe there are a lot of ethical concerns with that. And I even have a lot of potential clients come to me and say, well, my husband has an attorney and my husband's attorney said he'll just draft up the agreement. And I always caution potential clients against that, because ultimately as an attorney, my fiduciary obligations are to my client. I'm always here to represent my client and get a good outcome for him or her. So that's number one. The next thing that I see and hear a lot is kind of what Craig said as well. I don't want to go to court. I just want to do mediation. And that would be great if that was possible. But just like a divorce takes two people, just like a marriage takes two people, a divorce takes two people. And while mediation is very often successful, it's not a guarantee. And we can't just leave you in limbo in that way. The other misconception I hear regarding mediation is the idea in some people's mind that mediation is meant to be a reconciliation effort. Certainly, if parties want it to be a reconciliation effort, that's fine. But at least as far as Texas courts are concerned, the court's goal is not to reunify a couple. It's to amicably separate them, not amicably, but separate them in a just and right manner and make sure everything is done above board and make sure all issues are addressed comprehensively.
I like that you steered away from the word amicable. That is something that in Colorado, it is embedded in our statute that the goal in our process is to be amicable. And before I turn it over to Craig to speak on some misconceptions, I think that is one that I see often is people, again, think that this entire concept is mutually exclusive. You must be mean or you must cooperate. There's so much middle ground. So Craig, I don't know if you have anything to piggyback on that for Colorado and a lot of misconceptions you see here.
Well, I think I would just kind of reiterate what I said before, is that the people who think that there are only two options there, right? It's the Kramer versus Kramer, or the Marriage Story, all of these movies about terrible, horrible, horrific divorces that scar everyone for life. And people who've heard those stories from their friends, right? Like, everybody that calls us, oh, I had this friend who went through a divorce and they had this, that, and the other thing happen. And, you got to take that with a grain of salt. But the goal, maybe I'm making this too simple, but I would say that every good family law attorney is looking to collaborate. They're looking for ways to reach an agreement. In Colorado Springs, we've got 3 hours at the most to do a final orders hearing. And if we've got to do financials and kids and child support and spousal maintenance and all of these different issues in 3 hours, there's not enough time. And so good attorneys aren't going to want to go into this hearing and have to resolve 6, 7, 8, 9 issues in 3 hours. There's just not time for that. And so a good opposing counsel on the other side, where we can resolve and see what is truly a position that we can't resolve with the other side, that truly needs a judge to decide. That's the ideal. That's the goal. That's the way that these things get done well. And so people who think, going to court is a failure and the only way to be successful is not going to court, that's one of the big misconceptions. And really what the process actually looks like. It's not like every other area of the law. It's not as glamorized as Hollywood makes it out to be. It's a lot more mundane and a lot more hard work than you see in a movie.
Yeah, and you touched on good counsel and good opposing counsel. Is there any area in there where you are counseling your clients or potential clients on not only the misconceptions, but how to be collaborative in the litigation process? And it may not just be Craig, but for the panel, anyone have ideas or times where they've found themselves not working with opposing counsel, but working with their client on, hey, this is something we can settle. Let's think through it.
Yeah, I would say anytime anyone calls and says, I want full custody,
Yeah.
that's the one. I want full custody, where they don't understand what they're saying, or even if they do understand what they're saying, how unreasonable that is. And so you got to spend the time with the client and teaching the client and educating the client so that they understand, a bad spouse does not mean a bad parent. And a judge is not going to think bad spouse equals bad parent. There are bad things that somebody can do, but the judges want to give people a chance. It's better for these kids to have both parents in their lives, both good parents in their lives. And so if a parent is trying to redeem themselves, if they're trying to get better, the judges are always going to give them that. So that's the number one, that educating potential clients all the way through is, I want full custody. That's always number one of you. No, you can't do that.
Yeah.
I'll echo on that with the scorched earth, where you've got that potential clients like, oh, I don't want them to have anything. And, I'm just going to go get rid of everything, or I'm going to run everything into the ground. I mean, I've had, those who I want to run the business into the ground. I'm just going to stop working, or it's not beneficial to you or your case or your image in front of the court if you were ever to get there.
Well, what about the opposite direction? Because we've talked about, it's misnomers, what we're talking about, and how we're really leading our clients and opposing counsels and potential clients to, this is not mutually exclusive. We have to go through the process. We have to work together, or we should work together. Or how do you counsel people on the other side? Where do we see things go wrong, where we have those people come in like, we agree on everything. Everything is great. There's no problems here. And then it switches.
I've had cases fall apart over a china cabinet, a TV, a bed, a furniture set. And it's the most random things. And, when we have potential clients call in and say, oh, we know exactly what everything we're going to do. It's like, okay, well, that's wonderful. I'm happy for that. We can work along that and try and get everything, agreements all drafted up and filed along with the petition to make this process as quick and painless as possible. But if it happens to go awry, here's what we'll do. Here's what the next steps would be, and making sure that there's at least that full knowledge of it happens. Yeah, and it's over the weirdest things sometimes.
Yeah, I'm sure we all have those war stories. I mean, everybody I think has heard about the Beanie Baby case where things went just to we've all seen the photos of the people doing that, and it's funny and it's tragic, but it's also not. In my experience, I've found that there's an underlying issue. It's not the Beanie Babies, it's not the china cabinet. It is the underlying dispute and the emotion that's going with dissolving the marriage, dissolving the family, and helping people work through that, which I think is, the intent and spirit of the collaboration process. Is this doesn't have to be sit in a courtroom and pick out your Beanie Babies or fight about this stuff. It should be, hey, how do we find the points that we agree on and where do we go from there? And so I think the next question that we have from the channel is, do we, as lawyers or even non-lawyers, is there specialized training or certification to do a collaborative divorce? I guess we can ask by state because that's probably the best way. So starting, Najmu, I haven't spoken with you recently. Texas, is there specialized certification there?
Yeah, you can get certified in that collaborative law process and be one of those folks who walks people through that process. Of course, there's also a lot of this just comes with experience. When I started, it was like banging my head against the wall because I was like, why do you care so much about who has the right to enroll a 1-year-old in school? And then, as I kind of got further into practice, I was able to understand that it's, like you said, Karlee, sometimes something bigger is underlying. Maybe it's a principle, maybe it's some fight they had before they decided to separate. So while, yes, you can get trained in that collaborative law process, I do think a lot of it just comes with showing empathy and compassion for your clients and understanding that for you, it may just be your job. This may be something you don't think about in 6 months, but these are things people have to live with, at least for a lot of people, the next decade or so, for some people for the rest of their life. So for me, it's really important that my clients walk away with the settlement, not necessarily that they're happy with, but that they feel heard, and that whatever the Beanie Babies or the toaster or the pack of crayons, whatever that issue is, they at least feel heard, and that maybe we can split, not maybe a bad saying, but split the baby and let people walk away content.
Yeah. Brian, Craig, any specialized certifications that you're aware of in your state to do a collaborative divorce?
No, not in Washington. There's a couple of professional organizations for, those who practice it as a primary mode of practice, but no, there's no specialized license required.
What about?
Other than undergraduate law school, passing the bar, all of those things that we have to do? No, nothing else other than that.
No, and I think I'm laughing because this is a very common question, and it's obvious to us of, no, we're lawyers and this is not only what we were trained to do within understanding the laws, but this is our whole purpose, is to help people solve their problems. And the easiest place to start is by, what do you want and how do we meet someone in the middle for a good outcome? It's not the best outcome, but it's better than the alternatives of having something forced upon you by the court or other outcomes that may not be as desirable. When you decide the outcome, it's always better. And so there's another question from the panel that I think is perfect for this line of questioning of where we currently are in a discussion, which is, if instigating conflict is broadly considered to be inappropriate or maybe even unethical, why do some firms insist on escalating it, or some opposing counsels or parties? What have you seen on this? May be the $1 million question, is why are we having so much conflict when we don't need it?
And that's what's hard, is you've got such a varying degree of what an attorney thinks is instigating conflict. And I can provide kind of a anecdote. I've had an attorney accuse me of being unethical to a court because we initiated a discovery process, which, discovery is just big requests for documentation, questions to answer, things of that nature. And the court actually responded to this other attorney saying, well, there's the considerations of malpractice, perhaps, if we don't dive into the factors necessary and obtain the information needed for this particular case. So I would disagree, but I think that's always the biggest challenge, is every attorney has a different sort of perspective on what is the instigation of conflict. I think the bigger challenge is, as attorneys, maintaining our kind of emotional distance from maybe sometimes the anger and frustration that our clients are feeling, or maybe the other party feels in relation to some of the actions going on in court that would be construed as conflict, and setting that realistic expectation of, here's what this really means. This is what this is. This is what we're doing. It's not meant to be poking you or anything like that. or accuse you of anything. It's just part of the process.
Do you have any tips or tricks on how, when you're met with a just combative opposing counsel or opposing party, do you have any tips or tricks on how to, excuse me, on how to de-escalate that? I think that's something that newer lawyers often struggle with because they come in like, oh my God, why are we all so mean to each other? Any advice to them?
Pick up the phone. I think that's an art that has been lost, and while email and now even text is, significantly quicker, much more efficient, a lot is lost in translation. So when I get one of those emails that seems a little crass or a little aggressive, the first thing to do is picking up the phone. And 9 times out of 10, there's an apology of that's not what I meant. I'm just, we're in a rush. I'm trying to get something out. And I think it helps also foster those relationships that are really important within our profession, those connections, the networking, just to build that reputation between attorneys and be resources.
Mhm. Najmu, what about, I know you're a very kind and peaceful person by nature. And I know that there's a lot of cases that have a party on the other side that doesn't have an attorney. We call them pro se in Colorado. I'm sure there's similar terms in each state. But how do you navigate that when you're dealing with someone on the other side who doesn't have counsel and sees you as enemy number one?
Yeah, that's a great question. I mean, I always reaffirm that, like, listen, I'm just the person getting you guys divorced. I'm not your enemy. I'm not here to harm you. And I treat them the same way I would treat an opposing counsel, with respect, with honesty, and with transparency. I'm not here to take advantage of someone just because they don't have the legal training that I do or any of the folks on this panel do. And I repeatedly reaffirm that. And sometimes I've told my clients, like, hey, you can tell her that, like, I'm not here to, like, play games. I'm not here to hurt her or hurt him. And sometimes that works, because sometimes they just need to hear that, like, I'm not here to ruin this for you. And like Brian said, often a phone call helps. Often just getting that crazy email and taking a beat to not respond right away while I'm also feeling all of those heightened emotions, that helps with dealing with those cases with pro se people, because it can be difficult dealing with pro se folks who don't know the process, and it might feel like they're delaying it or intentionally making it more difficult. But I like to remind myself that this must be really scary for them. I think even if you have a lawyer, even if it's a good lawyer, being in court is probably really scary for most people. And to do that without an attorney, but then there's an attorney on the other side, that probably feels a lot worse. And so I try to remind myself of that and try to understand from their point of view why I might seem like the enemy.
Yeah. Craig, you lead one of our larger offices and locations, and you have some very experienced attorneys in your office and LLPs as well, which is unique to Colorado, and some newer attorneys as well. How do you foster this kind of collaborative approach within your office or even broader reach within the firm?
How do I foster? Well, I think the only thing that I could take any credit for with my team and the way that they approach it is getting the right people on board. There's an attorney that works with us now who, she was opposing counsel on a number of cases, a number of really nasty cases where she and I, like, it was me actually doing the case and her on the other side. And her approach where she came into it was extremely collaborative, and let's talk and let's think about it. And what matters to your client, what matters to my client, where can we find these intersections? And two cases, and I tell her this all the time, two cases that we did, I would have taken that to hearing 99 times out of 100 with another opposing counsel on the other side. But she came on, and that approach that she took, when she started looking for jobs, that's who we wanted. That's the type of person that we wanted here. And so, the people and the attorneys, your reputation precedes you, right? Like I talked before about how getting a good opposing counsel, really smart, really knows what they're talking about on the other side, is my dream, because it allows me to work with that person. But you got to be that person on your side too, right? And so what we do is going to follow us. Colorado Springs is a small, big town. Someone told to me today, small, big town, and your reputation precedes you with the judges, with the opposing counsel. And so you burn a bridge with somebody to represent one client, that bridge is burned with every other client that you've got. And that's your reputation, and that's what's going to follow you. And so, I haven't done anything special. The people that I've got, I think are really, really good, but that's the approach. Is your reputation is all you've got in this business. And once you burn that bridge and people talk, you're burned, and you're not the good opposing counsel on the other side. So make sure on everyone that you do, you are doing the right things, regardless of what the other side is doing, regardless of if opposing counsel comes in and flames you and yells at you, you're doing the right thing regardless. So that's what I think the attorneys in my office try to do. I think that's the right approach for everybody.
Yeah, and this is something on the firm as a whole. I think we really try to meet families where they are, and we recognize that families in 2025 are not families in 1955, and there's a lot that's changed from then. Or, even in 2020, the world has changed so much since COVID. And, I'll just ask, we're running short on time, but I'll ask the panel, what are you seeing now that we've defined and dispelled some misnomers? What are you seeing coming forward in our office or opposing counsels in the spirit of collaborative divorce that you hope we can all take forward and continue in our practices?
From my perspective, I get a lot more attorneys who are a lot less litigious, a lot more willing to try and collaborate, try and, see if we can figure these situations out and save people money, time, stress. It's no secret that divorce is a very difficult, stressful process, and I'm glad to see more professionals trying to navigate this without the screaming and the yelling and, I'll see you in court and everything else. And, Washington is very different than what I'm used to. I was barred and licensed in Colorado for about 7 years before I came out here. And the processes are different. There's a lot more court interaction here in Washington than Colorado. But for the most part, almost without exception, when I pick up that phone, I'm calling opposing counsel. It's like, okay, how can we work through this? What can we do? Here's our concerns. What are your concerns? Where do we meet? Whereas not even, 5 years ago, 6 years ago, it was a very different landscape. It was much more, well, I'm going to go file this motion and I'll see you in court here and we'll just argue it out there. A lot less of that willingness to, let's just see what we can do here. Let's find a resolution that just works for everybody.
Yeah, absolutely. Anything else to add on that? That's eloquently said, Brian.
I absolutely agree with everything Brian has said. And I think the thing for a lot of folks to remember, both attorneys and anyone in the court system, is that going to court takes a lot of time. I obviously can't speak for any other office, but in the North Texas area, the courts are so backed up that even to get just a preliminary hearing, just to set some sort of interim child support or interim possession schedule, right now I'm setting them out in August and September. By then we could have settled the whole thing. And so not only is it more cost effective, and it's also more time effective. And so that's something I always try to remind my clients and remind the folks, my team, that for us it's a job, but it is people's lives and it's people's money and it's their time. So collaboration is always a good thing, and it's always also better for the attorneys, right? It's always nice to sit across the aisle from someone who is also like-minded and also wants to reach a resolution and not just file every motion that they could or go to court on every small thing they could and get the attorney's fees on whatever.
Yeah, absolutely. Well, I'm looking at the time and making sure that we are close to schedule as possible. I'm never known for sticking right to a schedule, though. So we're going to do one quick rapid fire round, which is parting words. What is the one piece of advice you would give clients or potential clients on the litigation versus collaborative approach? And I will start with you, Craig, since you were the last person to speak.
To clients or potential clients, the one quick piece of advice I would give them is to extend your former partner the grace that you want them to extend to you. They're going through a really hard time. You're going through a really hard time. If you approach somebody else with grace and patience, it doesn't mean you have to agree on everything, but if you approach them with grace and patience and compassion, you're going to get a lot farther in life and have a lot better, more satisfactory outcome, whatever process you go through.
Great advice. Najmu, what do you have?
I would remind people that collaboration allows for a more customized agreement. When we go to court, we are leaving it up to the judge, who most of the time they get it right, in my opinion, but they are only hearing a snippet of your life, and they may not agree with what you agree with on what is most important to you. You know your family and yourself, and if there are children involved, your children better than I will ever know your family, than the judge will ever know your family. And that collaborative approach allows you to have a little bit more say in what happens to your family and your life.
Brian?
Be honest and upfront with your attorney. The absolute worst thing that can happen to us as your professionals is to have something come out of left field that we just weren't prepared for, that you knew about and we didn't know. And because 9 times out of 10, you're going to be the one who is most able to determine if the collaborative process is going to work for you and your family, because you know your partner way better than we do. And if that process is going to proceed and you think there's going to be some success, then it may work for you. But that being said, litigation is not what it's made out to be. It's not. And there are times where being litigious and being a litigant is important. When you've got hidden assets, when you've got, serious concerns with children, or, there's just, you guys are so far apart from each other and you knew that was going to happen coming out, collaboration is never going to work. So we just need to go through the traditional path, and your attorney needs to know. That way we can appropriately advise you on what we think that best path would be.
Yeah. All right. Well, thank you all so much. On that note, may we all get back to our work and our clients, and collaboration and litigation. That intersection is settlement. Go do good work. Have a great day. Thank you all for joining us. Bye.